review application में apply करछु मिलेनी एकदम
You want adjournment?
time
After order 30 is on. Land counsel for the petitioner, 6 for an adjournment. Produce the documents as mentioned in the order dated 26/2025 as well as 18/7/2025. Court of Justice number after ensuing puja holidays.
Item number 17 महिला.
Just to
Item number 17 after puja holidays.
any interim order is.
No, ma'am. That no.
Land counsel for the, you are for the petition?
Yes, sir.
Land counsel for the petition 6 for an adjournment. Item number 17. Yes.
Supplemental list, item number 1.
Thank you. Here in this case, two appellants said that one.
There are two appellants. One is died. It's a on
Panu Vera.
died after the fact sitting in the.
Just we have mentioned it.
Yes, sir.
Panu Vera is date in a order dated 17/9/2025. And we have further mentioned that so far as Bimba Vera is concerned, custody certificate is in produced is in custody for more than 15 years reports on how.
Near 6 months.
Now, what you have filed, a bail application.
Yes, ma'am.
For appellant number 2.
Yes, ma'am.
Also. Look, IN number 276 of 2025. Sorry, 275. 275 of 2025 is an application for bail of appellant number 2, Bimba Behera. From the custody certificate available on record, it dated for example, dated 17/9/2025. It appears that he has remained in custody for 14 years and 6 months, including the period of on remission. Land counsel for the petitioner submits that since in spite of the paration of the paper book, there is no chance of early hearing, the bail application of the petitioner may be favorably considered. Land counsel for the state offers the prayer for bail, considering the submission made by the land counsel for the respective parties, period of detention of the petitioner in judicial custody and absence of any chance of early hearing. We are inclined to release appellant number 2 on bail. It abatement order to pass any. We are passing the order like them since the appellant number 1, Panu Behera, is dead. As per the death certificate produced by the land counsel for the state, the appeal, jail criminal appeal, so far as appellant number 1 is concerned, stands abated in view of one so far. Order may be communicated. Order to be communicated. Yes. Okay. And of which neither has stay relation of final.
Item 2.
The sole appellant. You are there. Sole appellant. कितने वर्ष हैं? 17 ନ order ଦେବ।
16 ବର୍ଷ।
So
2010 man. First,
2010
first December 2010.
single murder,
Date of arrestment.
single murder and multiple murder.
Rape and murder. Nothing certified document.
yes
Certified.
that's
Yes, Mamata Mahanti.
Yes, sir. I am receiving paper copy Saturday.
Hmm?
I am receiving paper copy Saturday. And you prepare next after vacation. Regrets.
the period after
Application.
Madam, you have to file a bail application.
Sir, 3-4 दिन टाइम ହେଲା ତ ମୁଁ କରିପାରିଲିନି ଟାଇଫଏଡ୍ କରିଛି ଆଉ କଣ
3-4 ଦିନ ସମୟରେ ଆପଣ କରିପାରିଲେନି ଗୋଟେ ବେଲ୍ ପିଟିସନ।
ସେଠି କିଛି ମୁଁ ଭି ନାମଟାକୁ ଅପେକ୍ଷା କରିଥିଲି ଲିଗାଲ ଆଇଟମ୍ କିନ୍ତୁ
no no go and get it done now and come
ଆପଣ ନେଇକି ଆସନ୍ତୁ ଗୋଟେ
pass it over.
ଲୋକ
13 years he is already there
ଆପଣଙ୍କୁ ଏନଗେଜ କରାହଉଛି ଆପଣ ବାର ରେକମେଣ୍ଡ କଲା ଆପଣଙ୍କ ନାଁ ଗୋଟେ ବେଲ୍ ଆପ୍ଲିକେସନ ଇଏ କରିବା ପାଇଁ ଆପଣ କହୁଛନ୍ତି 3 ଦିନ ହେଲାଣି ବେଲ୍ ଆପ୍ଲିକେସନ କଣ ଲେଖିବେ କି ଯୋଉ ଇଏ ଇତିହାସ ନା କଣ
ଆପଣ ଏବେ କରିକି ଆଣ
କରିକି ନା
Pass over.
ନେକ୍ସଟ ପାସ୍ ଓଭର
Item 4.
नेक्स्ट चिन्मयी स्वाइन इस सब से जो बात हुई थी से अभिजीत
जैसी ଆସୁନାହାନ୍ତି if you can in this matter
just write a bail application is in custody for more than 13 years and file it. Okay. Item number 4.
4
Yes.
just now you small application
Yes.
you send your junior who can give it
Yes, yes.
एटा 500
500
कर दियो है ना यहाँ पे लिखी देवे प्लीज ना लिखी ना
Mr.
is appointed as the MI custody.
It's very effort.
When the matter is listed, the Learning Council was engaged in this case as engaged की कोई क्लाम में से list
हमें एक बार ना सीखते हैं
ठीक Mr. Chinchan for the for you fast over to me. ये bail application गुड़ा को जितने तीन रो और चार रो दियंतु है ना हाँ यस नेक्स्ट
Item 5.
ପାଞ୍ଚ ଦଶ ମିନିଟ୍ ବସିକି ସବୁ କଥା
Your Lordship, day before yesterday, I have received the paper book. Your Lordship, course of day, I will file IA, Your Lordship.
कोर्स ऑफ द डे ने आनी कि नहीं दियंतु
Okay.
हाँ
अंडरग्राउंड पीरियड देखନ୍ତୁ
12 years, Your Lord, more than.
12 years, yes.
Life.
Get it.
Convicted life, more than 12 years.
पास ओवर नेक्स्ट
Item 6.
यस मिस्टर महांती
Appellant is in custody more than 11 years.
15-12 केस ऑफ सिंगल मर्डर
Yes, single murder and also 307.
307 now.
Yes,
that means eyewitness is there
yes, yes.
single blow knife
Knife.
part of the body
Belly.
Son killed the mother. Who is injured witness?
Other villager.
Huh?
One other villager.
PW?
Height.
Heard the learned counsel for the petition, learned counsel for the state. Considering the submission made by the learned counsel for the petitioner, for the petitioner is in judicial custody for more than
11 years.
11 years. And there is no chance of early hearing of the appeal in the near future. Even though paper book has been prepared
No.
and even the paper book has not been prepared. And after hearing the learned counsel for the state who has not disputed regarding the detention period, custody period of the appellant, we are inclined to release the petitioner on bail, stay relation of crime.
Order may be.
Yes, madam.
Item 7.
May I please go? Sir, appellant is behind bars for more than 15 years, my lord.
15 years.
My lords. Conviction under section
9/7/2010. 6 years, yes. 302 case.
My lords. Conviction under section 364, 302, 201. Lords.
Minor boy.
Minor.
Certificate.
आगु रिजेक्ट ହେଇଥିଲା
No, my lords.
15 वर्ष आगे ये भी मिसिंग ऑन रिमिशन पूरा पता नहीं. Heard the land counsel for the petition, land counsel for the state. The land counsel for the state has produced the custody certificate to show that the petitioner is in judicial custody for more than 15 years. Custody certificate is taken on record. Considering the submission made by the land counsel for the petitioner, that there is no chance of early hearing of the appeal in the near future, and keeping in view the period of detention of the petitioner in judicial custody, we are inclined to release the petitioner on bail. Allowed.
Other may be come.
Yes.
Item 8.
Order की interim appeal.
पेपर बुक टा
फाइल करो कितने वर्ष रहे हैं आप 2012
13 वर्ष 2 मास
13 वर्ष दिमाग पासवर्ड नेक्स्ट
Item 9.
9 may please, Lordship. Your Lordship, the IA is already filed. It is in the record, Lordship. In fact, there are 2 JCRLA, out of which the first one has been abated because of the appellant having died, Lordship. Now, the second one is there for which I am placing, Lordship.
False James এটা পঞ্চিশ নো
ये bunches, for whom only I am placing. Lordship.
कैसे वर्ष ला रहा
Around 15 years, Lordship.
11 परा 11
10 months at least.
14 वर्ष
14 वर्ष 8 मास
सिंगल मर्डर
No, single matter, in fact, it's a case, Lordship, where around 5% have been set ablaze, Lordship, and they succumbed 5%, and 2% were injured. Case is that, Lordship, the other appellant who has been
Yeah. Considering.
But death certificate of the other, it has not been evaded so far.
nahi, order ଅଛି ନା other ଯୋଉଟା
Okay.
JCL number 76 of 2016
Separate application.
ଦିଟା ଅଲଗା ଅଲଗା ଫାଇଲ ହେଇଛି JCL
अक्षय कुमार स्वाई।
ଆଜ୍ଞା
ସେ
ସେ
appeal
evident
କୁ
ହେଇଯାଇଛି।
ମଧ୍ୟ ହେଇଯାଇଛି।
अच्छा ठीक।
The Learning Council for the state has produced the custody certificate of the appellant to show that he is in judicial custody for more than 14 years. Custody certificate is taken on record. After hearing the Land Council for the respective parties, taking into account the nature of evidence available on record, while not inclined to release the petitioner on bail on merit, but taking into account the period of detention, 3 months. Yeah,
interim bail for 3 months.
order, yes.
Great.
interim.
Maybe communicated.
Yes, come.
Grateful.
Yes,
Great.
next.
Item 10.
Lordship, I'm appearing virtually in item 10, Lordship. Custody certificate is already there. Mr. Mishra will tender it across, Lordship. We could not file it, Lordship. I have already ordered
9.
Lordship. 16 years, 8 months and 6 days, Lordship.
Yes, Yendu.
I'm physically handicapped, Lordship.
No, it's all right. This appeal has been filed by only one
Jail appeal,
appellant.
Lord. Yes, Lordship.
Bangara alias Sadananda Swine.
Lordship.
Bangara Sada Swine. Kete varsh heichi tano?
16 years, 8 months, 6 days.
Including period of
Remission.
remission or not?
Plus.
Yes, Lordship.
Baki conduct hochi good.
Very good.
All right, hard, the Land Council for the single murder.
Is
Lordship.
it single murder case?
Lordship. Lordship.
Now produce the custody certificate
Why?
to show that petitioner is in judicial custody for more than 16 years. Custody certificate is taken on record. Considering the submission made by the Land Council for the respective parties, nature of evidence available on record, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioners on bail, stay realization of fine. Yes, order be communicated.
Item 11.
May I please?
Grateful, Lordship.
And let applicant inside the custody since 13/1/2011 for period of 14 years. With single murder of
No, it ଅଛି ତ ଦେଖା ହେଇଛି 13/11
2011 ରହିଛି never release on bail.
just a minute 13/1
2011
2000 ଦେଖିଲ ନା ଫାଇନାଲ ଫର୍ମ ରେ ଲେଖା ହେଇଛି 13/1 ବାହାର କର ଫାଇନାଲ ଫର୍ମ 13/1/2011 ଆଉ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଦେଖଉଛି ଅର୍ଡର ସିଟ୍ accused produced in custody UTP produced in custody UTP ना बेल जाएंगे तभी बाकी हाई कोर्ट तो बेल है नहीं और इज राइट अगर बेल जाइथिले कि ना रिजेक्ट ही
मुझे never release on bail.
तो आपनकर होची ता 14 वर्ष 14 years 8 months
8 months.
केस कौन
Single murder of wife. Means there is no evidence available on the record.
Eyewitness count? No.
No eyewitness.
Circumstance.
Circumstantial evidence and they also become hostile. My lord,
all right hard the Land Council for the petition Land Council for the state considering the submission made by the Land Council for the petitioner that the petitioner was taken into judicial custody in connection with this case on 13/1/2011 and as such he has remained in custody and he was never released on bail during trial or during the pendency of this appeal. And as such, he has remained in custody for more than 14 years, 8 months. And it's a case based on circumstantial evidence, and there is no chance of early hearing a legal criminal appeal. We are inclined to release the petitioner on bail allowed.
Published.
You are Mr. Tapas Divedito?
No, my name is Susan Kumar Samandre.
Please give the names. Item number 11 तो.
आगे भी नामा फाइल करतील पछि
अच्छा, ठीक है.
published.
All right, next.
Item 12.
May I please, Your Lordship? My lord, appellant in custody since 12/8/2013. In the meanwhile, more than 12 years in custody. Earlier, bail was rejected and sole appellant.
Custody sir.
It is not called.
नहीं अच्छी है ऑर्डर टा अच्छी फाइनल फॉर्म देखो जी देखो
12/8/2013.
फाइनल फॉर्म तो मारंतु क्लिक करंतु आइले फाइनल फॉर्म रो 13 नंबर कॉलम को पढ़े आछंतु दैट इज इन द थर्ड पेज
Arrest on 13/8/2000.
हां
13.
13/8/2013 ହେଲା तापर पळे आसन ऑर्डर शीट को देखंतु ता ऊपर अछि ऑर्डर शीट रे सब गुडे लिखा होछि अक्यूज प्रोड्यूस्ड इन कस्टडी तामन सेठी से बेल हेइनी टोटल जजमेंट पर्यंत प्रोड्यूस्ड इन कस्टडी सब जाछि सेठी भी बेल हेइनी कि हाई कोर्ट रे मध्यम बेल हेइनी तो 10 is custody period is
More than 12 years.
more than 12 years, right?
More than 12 years.
बाकी जा एटा कोन मर्डर केस
Single murder, appellant killed her wife.
आई विटनेस नथिबे
For night. Occurrence witness one is there. At the time of occurrence,
PW?
PW 8.
8 is an eye witness माने तार
Sorry, PW.
नहीं तो आई विटनेस ने खाली एमती आई केम टू नो अबाउट द ऑकरेंस
Strangulating.
My
I
lord.
have not seen the occurrence.
My lord.
आई विटनेस गुड घर भितर घटना है आई विटनेस वेरी
Outside that room, he said,
Strangulation.
हाँ नहीं नहीं you said that eyewitness is there.
Eyewitness.
eyewitness may be the family members, it's all right. बेले बेले पुओ झियो एमाने बा घर लोक
Hospital was in the next.
10/11 is post occurrence witness. So they
Ah,
came to
post
know they
occurrence.
got the shouting.
All post occurrence.
Post occurrence.
Post occurrence.
all right, heard the land counsel for the petition, land counsel for the state. And the land counsel for the petitioner submit that the petitioner was taken into judicial custody on 13/8/2013. है ना? Neither he has been released on bail during pendency of the appeal nor during pendency of the trial, and as such he has remained in custody for more than 12 years. The case based on circumstantial evidence, there is no chance of early hearing of the appeal, and therefore the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail. Consider the submission, nature of evidence available on record, period of detention in judicial custody, absence of any chance of early hearing, bail allowed, stay realization of fine. Order be communicated. Next.
Obligement.
Item 13.
Your lordship has called for the custody
Custody
certificate and contempt.
Asila. Kete ବର୍ଷ?
13/5/18. Your Lordship.
Hmm. 14/5 February.
Including remission 7 years, 13.
कौन है टकी केस?
Sorry, Your Lordship.
What are the allegation?
My lord,
Eye
murder of
witness.
father, murder of the father,
Eyewitness?
1 PW 5.
PW5.
But before that, if your lordship can kindly have the 313 statements, my lord, before going to PW 5.
The CPS.
Yes. My lord has 313.
He has admitted it. Then.
My lord, the entire questionnaire to him is that you, in a fit of rage, have committed this. Your lordship will see the questions. The questions are very pertinent.
ମୋତେ ବାପା ଘରୁ ବାହାରି ଯା କହିବାରୁ ମୁଁ ରାଗିକି ବାପାକୁ ହାଣିଦେଲି.
Agya. You being
Fine.
angry hewed your father by axe. Then the question number 3 also, you became angry and brought an axe.
ସବୁ ତ ହଁ ଆଉ କଣ।
ହଁ ସିଏ ତାକୁ ମାନେ ପଚାରୁଛନ୍ତି କି ତମେ ଏଟା ରାଗରେ କରିଛ। It is not, my lord, your lordship will appreciate the exception that in a fit of rage, the question is put to him that way.
No, question is put on the basis of the evidence adduced by the
Yes.
witnesses, not that the judge has himself put the question.
Yes.
Question number
Without any
13.
My lord, so
Like what?
everybody attributes that anger is the part.
That is, it's all right, but
Anger is there.
cannot blame the learned
No,
trial
no,
court.
my lord, I'm sorry, my lord, probably it came out wrong. I'm saying that the questions.
A fit of rage, it has happened.
Yes, yes, sir.
Well, which part of the body he has solved?
My lord, Becko.
Neck.
Becko Jangha.
What is the effect of the injury? Which is the
PW9. PW9 is the PM doctor.
କେତେଟା ବ୍ଲୋ ଦେଇଛନ୍ତି? ନାଇଁ ନା ବड़ा ଏତେ ବ୍ଲୋ ଦେଇଛନ୍ତି?
6ଟା
5 ହଁ ଆଚ୍ଛା
6ଟା
ଆଟଲିଷ୍ଟ 5 ପର୍ଯ୍ୟନ୍ତ ଯାଉଛି ନାଇଁ ନାଇଁ 6ଟା
Yeah.
6ଟା
One anger is, one blow is understandable.
many blows.
Not big.
छुट्टी पर
Becko का
certificate produced after puja holiday. Yes, next.
Great.
Item 14.
Yes, 14.
Vashikas, they have sent the Veenama to the officer that's already intimated,
Yes, submit that she has
already submitted to the officer.
office.
These are the photocopies of the Vakalatnama. The original Vakalatnama has already been submitted.
Informant now, Lekam, the learned counsel for the state submits that she has.
What is the photocopy of the Vakalatnama?
She has received the Wakalatnama. Let the Wakalatnama be sent to the High Court Legal Services Secretary, High Court Legal Services Committee for engagement of a counsel for the informant. Matter be placed after puja holidays. Non-appears for the appellant. Yes.
Item 15.
Item number 15, Lordship has called for the conduct of the conduct, and he has not, the conduct has come.
Finally,
But he has seen this is they're sending.
you
There
want
is no
some
adverse
more?
report, but conduct they have already. Okay. No adverse report against the author.
No, this is inside jail.
Yes, sir.
We
ସେଇଟା
want,
ମଗା ହେଇଥିଲା
we want the.
ବାହାରେ ସେ ତ ନଥିଲା ନା
ଓ ବାହାର ଯାଇନି କି? अच्छा अच्छा
ଇନ୍ କଷ୍ଟଡି ସିନ୍ସ 19/12
19/12?
22 from the date of this
498-302.
ଆଜ୍ଞା the deceased is his wife.
Yeah.
She was found lying dead in the runner bean field millets by PW4 in the morning of the 17th millets. And the
You have got
person-
the deposition copies.
paper book is there.
Paper book is there.
Person of PW2 is that deceased and her husband, they had a quarrel in the night before.
106 has been applied.
Yes. And the
PW8
cause of death millets is poisoning.
What is your accused statement?
Accused statement millets, the question was put to me.
Question number 44.
44.
44. ମୋ ସ୍ତ୍ରୀ କେମିତି ମଲା ମୁଁ ଜାଣିନି।
ଆଚ୍ଛା ଘଟଣା
But I remember-
ପାଞ୍ଚରେ ମୋ ସ୍ତ୍ରୀ
ଲାଗିଆ ହେଲା ମୁଁ ଜାଣିନି।
ଜାଣିଲି ପରେ ଜାଣିଲି ତାର ମୃତଦେହ ଅଲଗା ଗାଡିରେ ପଡିଛି
ପୋଲିସ ବୋଧେ ଜବରଦସ୍ତି ନେଇ ଆସେ ମୁଁ ମୋ
with the doctor
PW7.
PW7.
That is homicide. PW7 says that is homicide.
contusion there.
Death is homicidal. Death is due to consumption of antemortem intake of some toxic irritant substance. Page 77 of the paper book, last line, parahite.
Cause of death ପୁରା reserve କହିଲେ ତାପରେ
ଏବେ parahite ର ଦେଖୁନାହାନ୍ତି page 77 paper book ର.
see that the cause of death of this can be opined after chemical examination.
Yes, after chemical examination that was given to her.
There are other
Inside paragraph 8, what he has stated.
Yes.
She says, the doctor says, I have opined towards question 3 that the cause of death of deceased can only be opined after chemical examination report of viscera is received.
What happened to the viscera report?
As I have found the stomach contents emitting pungent smell, mucosal congestion and submucosal hemorrhages suggesting antemortem intake of some toxic irritant substances poison.
No,
This is
what
my-
are the
I have
report?
next
C report was
page
obtained.
78 the
78.
paragraph 10. After
Ah,
perusing the chemical examination report, I have opined that the cause of death of the deceased is due to organophosphorus poisoning and complications thereof. However, injuries mentioned over the body of the deceased are consistent with assault. Now, your lordship may look at the injuries that is at page 75. The first injury is multiple nail scratch abrasions of size 1 into 0.2 cm present just above the areola of left breast. Second injuries are similar multiple nail scratch abrasions 0.3 into 0.3 cm present over the upper chest towards left side close to the shoulder joint.
Okay, ma'am, how do you say
The-
that it's a homicidal death?
With the cross-examination para 11.
Yeah, assault on the deceased, no.
But the
Assault on the deceased.
homicidal.
Assault on the, you see these abrasions or these
I'll place a PW8.
contusions, that is not the cause of death. Those are, it may be so that prior to intake of poison, there was some kind of quarrel or some kind of assault. But those are not,
Combined.
those are not responsible for the death because the death is on account
to
of
poison.
organophosphorus poison. So it might so happen that you may say that it's a case of under 490A also that he was subjected to torture. But question is that on the basis of this opinion which has been given, I do not know why this question has been put on paragraph number 11 as such. When the paragraph number 10 he has opined that it was a case of whatever it may be. So he could have very well said in the report itself that, but he reserved the opinion awaiting the viscera report.
Yes.
So he was not sure
Sure about
that it
the-
was a case of homicidal death.
Oh.
And after perusing the viscera report, he gave the opinion that it was a case of organophosphorus poison. So maximum it can be said that these are antemortem injuries, the injuries which were noticed and in paragraph number 2 of the evidence. But these are not the cause of death.
These are not the cause of, you know, so that's a combined effect of there are injuries are on the body of the.
Abrasions, how come abrasions a combined effect?
You see, ma'am, can it
Not
be?
a combined.
No,
effect.
Proper
just-
question the defense
Can it
counsel
be-
should have
can it
put,
be-
has not put.
You are to.
The proper question he should have put is that these injuries are possible when there is intercourse between husband and wife.
Yes, that was
That
the,
was the question which should have been put.
Let us say.
because the part where.
Exactly.
Those cases 106 would have been applicable. Let us say they were in that house.
Particular.
It's a case of purely it's a homicidal death case, strangulation or something like that.
Yes.
And the dead body was found in
Yes.
the room itself. Husband was only present.
Only.
Those are the cases, number of cases are there. But here is a case, the dead body was found outside. It was a case of organophosphorus consumption. Some injuries were there,
Injury.
which appears to have been caused to the deceased, right?
Yes.
But how it has been caused, of course, he has not stated anything, not explained. But these are not the injuries which has caused the homicidal death.
Unless you have the evidence that he is responsible in administrating that poison.
The
Unless you have that.
mistake, my lords, is that the doctor has not stated the time of death. If your lordship will look at the evidence, time of death कुआ ही नहीं कोई.
PW8 is the mother of the deceased. She said, Narayana sir also assaulted children by drinking liquor, for which my daughter left her 2 sons in the house.
What are the age of injuries?
एवढा भी कुआ ही नहीं.
So how can you correlate it with
I'll just let's
এই
see.
যে abrasion মনে করো 5-6 দিন তলর abrasion ହେଇଥିବ. Let us say you are telling about that the death took place time of death is 24 hours before my autopsy examination.
Yes.
That's all right. But this injury must have occurred just prior to that.
Just prior to the occurrence.
So if the death has taken place within 24 hours, suppose this injury goes back to 5 days.
There is no.
So that should be the evidence, because it can be detected by the change of color, all these things. The criteria has been laid down that how
Age
the
of the injury should.
age of the injury is a vital factor that has, I think that is not been ascertained.
The PM report was a silent for.
The postmortem doctor does not say while deposing in court as to when the deceased died. What was the time of death, which she noted from the during postmortem?
This
That
question, Mr.
simple thing
Panda, should not have been asked.
Which was?
Question number 11.
Lots many questions should not have been asked, but what can I do?
Many a time the conviction is because
What
defense lawyer.
can I do? Everybody Millers comes to the High Court. Nobody goes to the trial court or
Many a
follows.
time, therefore, the conviction is only because of defense lawyer.
Yes. No, it's not because of the defense law.
The question.
That is not the basis of the conviction. My submission is this, Millers. I may be a notorious person. I may have ill-treated my wife and my child. Where is the evidence that on the night before or soon
No,
before the
PW
incident, there was any ill-treatment of me by the wife?
Kindly see PW2.
PW?
2.
Yes.
Yes.
The occurrence took place. I'm reading the para 2 unit.
Right? In this.
The occurrence took place on
Was it tussle?
7/12/2022 in the night. The said night, there was a tussle took place between the husband and wife, Narayan and Joyanti, and closed their door. In the next day morning, 18/12/2022, while I was in labor work, the younger brother of Narayan Sahu intimated me over phone that the dead body of Joyanti Sahu was lying in the runner bin filled in the backside of the house of the Narayan Sahu. So I came up to the spot and found her dead body. I believe there's none. Your Lordship, kindly see PW8 for a moment. Again, Your Lordship.
8, huh?
I believe that Narayana has committed
No,
murder.
I'm
Is this
placing-
belief, Millard, sufficient to
I'm-
come to that conclusion?
Previous night, what
Yes, sir.
happened?
The tussle.
Tussle ହେଇଥାଇପାରେ. If the tussle does not
PW8.
connect to the death.
PW8.
PW8, Your Lordship. It's
Yeah.
a mother who says Narayan Sahu also assaulted children by Dikina, for which my daughter left her 2 sons under. She was assaulting the wife time and again. PW9 is also concerned.
Mother, she is the mother.
8 is the mother.
PW2 is an independent witness.
Yes, sir. PW9
My son Narayan Sahu always assault.
always assault me, my another son, my husband, also his wife and children.
Hmm.
He used to assault his wife time and again.
PW9 is the, who is he?
9 is the
Mother
mother.
of the appellant.
Gadi Sahu.
She says, my daughter-in-law was a good woman. My son always threatened to kill. And in PW9 and paragraph 4, she said during her stay of Joyanti Sahu with Narayan Sahu, he asked her to bring cash of 50,000 either from me or from the
Mother
mother.
is deposing of the son.
Pardon?
Mother is deposing against his.
Yes. So there is a constant.
Past behavior କଥା କହୁଛି ନା present behavior କଥା କହୁଛି.
PW8, 9,
PW2 ଟା ଆଜ୍ଞା independent କେମିତି ହବ ସେଟା ନିଜେ କହିଛି my cousin brother.
the independent.
ଆଉ independent କଣ?
Also, the Learning Council for the state has issued the jail conduct certificate, which is taken on the foot of this matter after entering Puja Hotel. Yes.
Item 16.
Yes, item 16.
Item 15. I am appearing for the bank mallet. I pray kindly taken up after Puja action, I shall take it, sir.
You are for the bank.
Mallet.
Mr. Biswal is there. All right, Land Counsel for the petitioner is present and counsel for the bank is also present. And he seeks for an adjournment put of this matter after entering the holiday.
Pardon me.
आपण का भाई?
Item number 14 mallet nahi. Item number 14.
हाँ. After item number 14. Interim bed पर कौन तम कोई भी matter कौन को आ लगी? तो दोनों. हाँ, तो informant appear कले.
Again.
से engage हेबे council पठेई जन इसी वकालत नवा. बर्तमान एटा छुट्टी परबु रहला हला.
Again.
Next.
Well,
Item 19.
Item 17.
17, 18 has been adjourned. Somebody made a mention that was all. You are for the
I'm for the bank.
17 number item. Who Pardyantu?
He's been taking adjournment. This is the 5th time.
Any order has been passed in?
No order, but he's telling the Tahsildar not to take possession because of the writ is pending. So he wants to clarify last time.
Item number 17 may be further base. Since no interim order has been passed, the authority is at liberty to proceed with the matter. Yes, item Mr. Ramchandra Panika is present, item number 17. Here dictation even to quite. Yes.
Item 20.
19.
Item 20, my lords, I am on VC, my lords.
No, 19.
My lords.
19.
Item 19.
Item 19, I am for the appointed bank.
What about the petitioner? Any interim order was passed?
No interim order.
You are supposed to obtain instruction
My lord.
whether the bank has filed an application under section 14 of the Surface Act for recovery of the possession and handing over the same to the petitioner. Petitioner is the auction purchaser.
Isn't the option purchase?
So, paisa apno nahi gale, apno step kon pain hona thi?
Lord, in fact, my lord, the bank has taken steps, my lord, to hand over physical possession. The opposite partner, two, my lord, the Odisha State Housing Board, my lord, the Housing Board objected that since this is a multiple plot allotted in favor of the borrower, my lord,
No, why you then publish that auction notice and accepted money from him?
my lord,
Question is that it was put to auction sale.
my lord, while the petitioner
ଆପଣଙ୍କର ଯଦି difficult ଥିଲା ସେ ଯୋଉ department କୁହନ୍ତୁ କି sir ଏ ଲୋକଟାର ଦୋଷ କଣ ହେଲା ଏ ଲୋକଟାକୁ ଆପଣ କଣ ପାଇଁ ପଇସା accept କଲେ ଯଦି ଆପଣ ଠିକ ଅଛି state housing board ଆପଣଙ୍କୁ କଣ କହିଲା that's a different matter.
while availing the loan, my lord, the NOC was, my lord, obtained from the Housing Board. Housing Board issued NOC in favor of the bank that you sanction the loan in favor of the borrower.
You return the money, then refund the money. Why did you accept the money? अरे ऑक्शन कले सी टंका डिपोजिट कला ताको एक्सेप्ट कले ताको पोजीशन देबेनी सी आसी हाई कोर्ट को केस करिया पई आपण कहउचंदी कोन ना से स्टेट हाउसिंग बोर्ड कहउची ना एटा को ये करंतुनी आपण चुपचाप बसी गले
Details of the
व्हाट फॉल्ट लाइज विथ द पिटिशनर
details, my lord, of the section 14 application, I shall apprise your lordship. Your lordship kindly
that
apprise.
instruction you the last order was passed on 37/25.
Yes.
The land council is not there, that's a different matter, but all right, put up after ensuing puja holidays. The land council for the bank who is present submits that on the next date he will apprise this court regarding the filing of application under section 14 of the Surface Act before the appropriate authority for recovery of possession and handing over the same to the petitioner. Yes, please this matter on we commencing for them to pay October 2025. Yes, next.
Item
My
20.
lords, item 20, my lords, I am on VC, my lords. My lords, the order dated 16/6/2025, whereby the application of the petitioner for release of his goods and documents have been rejected by the bank. That is at page 28, annexure 5.
Who is appearing for you? You are
My
appearing.
lord, I am appearing for, my lord, they have not solving a copy, my lord.
So,
No, copy has been solved on 30th of July 2025. As per the last order dated 25/7/2025, we have solved the copy on 30th July 2025.
yes, what do you say? Copy ଦେଇଛନ୍ତି କହୁଛନ୍ତି? You are supposed to obtain instruction.
Yes, my lord, so copy nahi bole.
You do one thing, give another copy is denying that not received.
My lords, as my lords, please.
Do the land and council for the petitioner submits that copy of the writ petition has been handed over to Mr. Tuna Sahoo, land council appearing for the Union Bank of India but it is controverted by the land council, and let another copy be served on this one. So put up after entering puja or litigation. Next.
Obliged, madam.
Obliged.
Item 21.
Item 21, may you please, Your Lordships. Your Lordships, item 21, I am for the petitioner. I am the mortgager in 2 loans, and I have taken those loans and I have defaulted in the
E-auction
payment that
sale
is
notice has been issued 18/7/2025, and the date of submission of the tender thila 2/9. What is the status of this?
It has not been auctioned yet, Your Lordship.
Huh?
As per my instructions, it has not been auctioned yet.
File an affidavit so that will the land council for the petitioner submits that in pursuance of the e-auction sale notice dated 18/7/2025, as per annexure 4, the auction has failed. And you would file an affidavit to that effect. Put up this matter after entering puja holiday. Yes.
Item 22.
In this case, the bank has filed a complete bid from
Mr. Arupananda Das, where is he? Why is there?
Malats, I am appearing on behalf of Mr. Arupananda Das, Malats.
So, have you received a copy of the writ petition?
Yes, Malats, and in the meanwhile, sales certificate has already been issued, Malats.
That is wrong, madam.
No, Malats, we have instruction sales certificate.
Just a minute. Have you got a copy of the sale certificate?
Malats, we are just obtaining it. Malats, we'll keep it just after vacation, we'll
All right.
furnish it.
We are mentioning that you have received the copy of the writ petition.
Malats.
All right. Your good name, land council?
Dipankar Acharya, Malats, on behalf of
Mr.
Mr.
Dipankar
Arupananda.
Acharya, land council appearing for Mr. Arupananda Das, submits
Malats.
that is appearing. He has received the copy of the writ petition from the land council for the petitioner, and he has received instruction also that the auction sale is successful and sale certificate has also been issued.
Yes, Malats.
The matter will be taken up after entering puja holiday to produce such certificate. Put up this matter on 13th of October 2025. Yes.
Deeply obliged, Malats.
Item 24.
23 टा पढ़ा लगी
Item 23.
22 पर 23 टा किन्हें नहीं?
Item 23.
Yes.
May it please your lordship, the petitioner actually challenged the order of the learned ombudsman while disposing the appeal.
That is annexure 1.
That is annexure 1.
What order he has passed? Come to the operating part in page number 12.
They have actually dismissed the order on the ground of no maintainability.
Come to that part. Please come to the operating part. You come to the after going through the aforesaid provision. The provisions have been quoted there. The definition of the complainant, so and so that has been quoted. And then you come to the internal page number 4 and running page is 12. Read it after going through the aforesaid provision.
After going through the aforesaid provision, it is doubtful if the pronounced by GRF.
If the order pronounced.
If the order pronounced by the GRF for giving power supply to consumer can be challenged before the ombudsman by a third party. For the sake of clarity, it is stated that this ombudsman can only entertain the representation of the consumer containing the grievance not addressed under section 42(5) of the Electricity Act of 2003. In view of these discussions stated above, the petition of the petitioner challenging the order of the GRF order dated 17/3/25 in case number such and such is not maintainable.
Hmm.
The Orissa Gazette, Orissa Electricity Regulatory Commission, Unit of Bhubaneswar, the notification 5th April 2004.
So you are not a consumer.
I am not a consumer.
Come to the paragraph number 2. Sorry, page number 2. Very fast line. Internal page is 2, running page is 10. From the papers produced by पूरा प्रथम line पर.
The top.
Top. अरे पूरा
From the papers produced by the parties, it is evidently clear the petitioner claiming to be an advocate and social activist has prayed for settling the order of the dated GRF Paradip in order dated 17.
So जौन consumer से ताकू power supply हेला GRF order अनुजाई हेला. You are an advocate and a social activist. How can you challenge the order before a GRF?
So actually, it involves the violation of the
Maybe whatever, it is not PIL.
Is it a PIL? PIL का power अछि काहाकू consumer को गोटे electricity connection दिया हला ताकू आपण एजिटे तांकर authority अछि ताकू decide करिया उदे ताकू you are a third party, you are not the consumer. हाँ आपण apply करथांते आपण को मना कर दी थांते कि कौन गोटे order pass करथांते you are a third party.
How are you aggrieved?
How are you aggrieved?
Actually, I am aggrieved because when I went to the JRF, they said that if you are aggrieved, you can go to because I cannot change my own order because they have given one illegal connection. And
How are you aggrieved? Illegal?
are you
It is a contract between the power supply company and the consumer.
X supplied, Y gave the line.
What is
As my esteemed brother point, it's a contract. You will pay electricity dues and they will supply. You are a third person, you are a social activist, and you are opposing that why electric connection was given to X house. How are you challenge this matter?
You are an advocate, you have to do something else, not challenging everywhere.
Are the learned counsel for the petition, learned counsel for the petitioner has challenged the order passed by the so and so. Here the order of the ombudsman, it appears that the petitioner is an advocate and a social activist, and he has prayed for setting aside the order of the learned GRF Paradip dated 17/3/2025. The GRF dismissed the complaint petition filed by the petitioner at the stage of admission.
No, my lord. Actually, they've had and they knew the facts. After that, they
It's all right. Many orders we passed at the stage of admission that has been written down. So, wherein the order of the GRF, where is that order? Have you annexed the order of the GRF? The GRF order indicates as follows. During course of the achi, है ना? सेटा को ये observation टा quote कर दो. Up to devoid of merits, है ना? The matter was challenged before the learned ombudsman one, है ना? OERC in CR case number OM 152 of 2025. The learned ombudsman, taking into account the relevant provisions and particularly the definition of the complaint, effect, efficiency, and electricity service, has been pleased to hold as follows. Quote, after going through this one, so no. The order clearly reveals that the petitioner is a third party, and electricity connection which has been given to a party cannot be challenged by a third party without any valid reason, and more particularly social activists like the petitioner before the GRA. And it's a contract between the supplier of the electricity and the consumer. The after
Petitioner has no privy.
and that is it.
Petitioner has no privy to it.
After hearing the land counsel for the petitioner, we are of the view that there is no illegality or infirmity in the order of the land and GRF, which has been confirmed by the land and ombudsman one. Accordingly, the writ petition being devoid of merit.
May I please commit to one line?
Yes,
My
next.
lord. Actually, the authorities have done illegal, at least they should have appreciated that it has been
It's not a
illegally.
PIL, Mr. Counsel.
They have added contempt
Yes,
actually.
next. Item number 22.
Item 24.
24. Mr.
As a matter
Chinchan,
of the earlier bail application was rejected in the year 2021. I pray that it may be called immediately after vacation. I will file it.
6 for an adjournment after Puja holidays. Next.
Item 25.
କିଛି ନାହିଁ ଆଇ ଏଗୁଡା କାଇଁ ଆସିଥିଲା ଗୋଟିଏରେ ଅଛି ହଁ ଆଚ୍ଛା କନେକ୍ଟେଡ ଅଛି କଣ ହେଲା କଷ୍ଟଡି ପିରିୟଡ ସାର୍ଟିଫିକେଟ ଆପଣଙ୍କ ପାଖରେ ଅଛି ଆଇ ନମ୍ବର 1 is an application for bail. Land counsel for the state seeks some time to produce the custody certificate. ଆଉ ଯାଇଥିଲେ କି interim bail ରେ?
Yes, yes. On account of death, whatever he
And also the conduct certificate. Yes.
15 to 2019 ଯାଇଥିଲି.
हाँ नहीं ना ठीक है तो आफ्टर पूजा हॉलीडेज आसियो कस्टडी सर्टिफिकेट आनिबे कंडक्ट आनिबे जो इंटरिम बेल पीरियड नेक्स्ट
Item 26.
अच्छी कितने पीरियड
10 years, 8 months, and 5 days.
दियन आगु रिजेक्ट जी
No,
सिंगल मर्डर
ମୋର 302 ରେ ଆସିବନି 305 304 ପାର୍ଟ 2 ରେ ଆସିବ। ମୁଁ ଦେଇଛି ଦିଟା ପାରାଗ୍ରାଫ ମୋ ଡେଟ୍ ଚାର୍ଟରେ
assaulted by means of an iron putty to whom କାହାକୁ
ସେ ତାଙ୍କର କ'ଣ ଫ୍ରେଣ୍ଡ ଥିଲେ ସେ ତାଙ୍କରି ଘରେ ଶୋଇଥିଲେ ସେଇଦିନ ରାତିରେ ତାଙ୍କ ଘର ସେ ବି ଶୋଇଥିଲେ
deliberately assaulted अच्छा you assaulted your father
ଫାଦର ନାହିଁ ତାର ଫାଦର PW7 ର ଫାଦର
अच्छा 5 and 7 are the
5 and 7 eyewitnesses but they have not stated before the IO anywhere.
NES.
The land counsel for the petition land counsel for the state. The land counsel for the state has produced the custody certificate of the petitioner, which shows that the petitioner is in judicial custody for more than 10 years, including the period of remission.
Including remission, 12 years.
Acha. Not 12 years, more than 12 years, including the period of remission. The land counsel for the petitioner submits that the, acha, is a lady actually. The petitioner is a lady. Acha, she has also produced the written instruction from OIC Badampur Badam police station to show that there is no criminal antecedent against the petitioner.
Jail conduct is also good.
The jail conduct is also good, as appears from the report submitted by the senior superintendent Circle Jail Baripada. The land counsel for the state of the prayer for bail on the ground of statements of the eyewitnesses, that is PW 5 and PW 7, as well as the post-mortem report findings. Considering the submission made by the land counsel for the petitioner, since the petitioner is a lady and is in judicial custody for more than 10 years, and then there is no chance of early hearing of the appeal in the near future, and paperwork has also not been prepared, we are inclined to release the petitioner on bail. These are taken on record. Yes.
Item number 27.
27. What is the custody period?
Custody more than 8 years.
Final form ଦେଖୁଛି 12/9/2017 ହେଲେ ହଁ 8 years ହେଲାଣି. ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି?
Eyewitness? Any eyewitness?
Based on oral as well as recorded dying declaration.
Exhibit dying declaration ଟା
Which exhibit? Exhibit.
Exhibit 2.
2.
Yes.
ଆଚ୍ଛା, ମୁଁ ପ୍ରଥମେ ତାଙ୍କର ନାମ ପଚାରିବୁ, ସେ ତାଙ୍କ ନାମ ରଜନୀ ବୋଲି କହିଲା, ସ୍ୱାମୀଙ୍କର ନାମ ମନୋଜ ବୋଲି କହିଲା, ଦେହରେ କେମିତି ନିଆଁ ଲାଗିଲା ବୋଲି ପଚାରୁ, ସେ କହିଲା ତାର ସ୍ୱାମୀ ଓ ସେ ଦୁହେଁ କଳି ଝଗଡ଼ା କରୁଥିଲେ, ଝଗଡ଼ା କରି ତାର ସ୍ୱାମୀ ବଜାରକୁ ଚାଲିଗଲା, ସେଇ ସମୟରେ ତାର ନଣନ୍ଦ ଡଲି ଓରଫ ସୁଆଂଶୁ ଝଗଡ଼ା କଲା, କିରୋସିନ ସୁଆଂଶୁ, ତାର ଭାଉଜ ତାର ମା ତାକୁ 108 ଆମ୍ବୁଲାନ୍ସରେ ଅଛି, ଏଇ ହଉଛି ଡଲି।
What is the age of this lady? What is the age of this girl?
Judgment.
The age of this. 27.
ମାନେ ଯେତେବେଳେ ଇଏ ହେଇଥିଲା,
Can you seek the court?
Are the land counsel for the petition, land counsel for the state. From the records, it is available that the petitioner is in judicial custody for 8 years. And it further appears that there are no eyewitnesses to the occurrence, and the case is based on oral as well as written dying declaration. And the dying declaration has been marked as Exhibit 2. Considering the submission made by the land counsel for since the petitioner is a lady and there is no chance of early hearing, we are inclined to release him on interim bail for a period of 2 months. Yes, next.
Item number 28.
Yes, Mr. Pari. The key by the Takina. It will be data.
Rejected.
3 months रे जाइଥିଲା तापर मिनास और मदर इन लॉ वी accused to taking into some here not interim action now केते वर्ष होला आपण कोन अपेक्षा करियो पड़ियो माने ए मैटर आमे कहिबू तापर आपण मगेइबे मीना साहु 2015 रो रहलानी 10 years कंप्लीट करियलानी 498 302 काकू मारथिला से मीना साहु is the 28 girls who have gone to death in her matrimonial house who is the मीना साहु दा होची ये सासू तारा what is the basis of her conviction
65.
हाँ
You don't 11 is a 11 and 12. 66 story. 60 judgment of 62. Must be in 70s.
you see the evidence of the witnesses paragraph 13 रे discussion है star witness तम कहउचंदी trial court 1 2 11 and 12 all of them have stated about this demand of dowry and torture बाकी evidence को जाना पड़ची जे on 5th September 2015 we are in internal page होची 13 ते जो judgment रा है ना on 5th September 2015 on the occasion of Janmashtami they sent a sari along with fruits to the house of the accused persons with the son and daughter
The son and daughter of the immediate person.
yeah
The governor and the guru. They requested the mother-in-law of the deceased to send the deceased to their house for few days. Her mother-in-law told them that they would not observe Janmashtami in the next week. During the same, both of them returned to their house and disclosed about the same. On the next day, that is 4 or not, at about 9:38, they were informed that their deeds were in serious condition. And were requested to arise from the house of accused person. Hearing the same, he along with his middle brother, his nephew, and Savitri Behra lived in the house of the accused person and found the deceased was burned to death by clearly killed. And he was found laying dead on the veranda of the house of the accused person. Thereafter, he proceeded to the prison of PSP and lodged it.
is there any dying declaration torture कथा ठीक अछि जन्माष्टमी ता पूर्व दिन जाइथिले एगुडा भी ठीक अछि बट
No dying declaration. In any case, he is more than 65.
are the land counsel for the petitioner and counsel for the state the petitioner is an aged lady of 65 years and she is the mother-in-law of the deceased deceased or na kon deceased or na ta kon me acha mamina behera okay the petitioner is in judicial custody for the custody certificate for देखिए এটা দেখি मीना साहब it appears from the final form that the petitioner was taken into judicial custody on 8/9/2015. And ସେ ବେଲ୍ ହେଇଛି 16/10/2019 and he was directed to be released from custody by the order dated 16/10/2019 as per the order of this court dated 14/10/2019. So 16/10/2019 ବାହାରିଲା କେବେ ଯାଇଥିଲା ଫାଇନାଲ ଫର୍ମ କହିଲେ 8/9/2015. अच्छा तापरे तो अपील को देखो अपील अच्छा बेल जाइसा इंटरिम बेल दिया जाता था 4 months by the order dated 9/10/20 4 months. तापरे
দুই মাস এক্সটেন্ড
extension होगा extension हाँ extension होगा तापरे again ताको interim bill दिया इसी by the order dated 2/9/21 मासे पाइन दिया इसी तापर सेटा extension है इसी 10/20 तापर पुनी extension 5/10 हाँ you are right 5/10 ने extension है इसी तो दिरो वर्तमान भीतर रशियों within 2 months of the marriage also reject ही prayer last merit reject ही 22/3/2022 और the land and council लिख रहे
That is some kind of and the directed to release from the order to soul of the nation as per the order of the soul.
During pendency of the appeal, the petitioner was released on interim bail for some period, and the bail application was rejected on merit last time on by order dated 22/3/2022. है ना?
एंट्री ऑर्डर हेल्थ ग्राउंड
हाँ
हेल्थ ग्राउंड रिलीज
हाँ on health ground, wherein it is indicated that the petitioner was suffering from osteoarthritis in both of her knees and facing difficulties. You know? Considering the land and council for the state opposed the prayer for bail, considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody, her age and fact that nothing adverse has been brought to the notice of this court during the period of interim days granted to the petitioner, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. This is এটা হচ্ছে 1670 of 2023 রে দেবে appellant number 1 মিনা সাউ এই গোটা গ্রামে বেল দিল হলো। Yes, next. আচ্ছা এটা অর্ডারটাও কমিউনিকেট করবেন সাংকে আপিল করলাম। It's next. Appellant number 1 গোটি অ্যাপ্লিকেশন আর একটা পেন্ডিং আছে সেটা থাও। ওটা হ্যাঁ 80 জন আছে পিয়ন। সিরিয়ালি করে দিন 3টা কোন 5টা দিয়েছেন 5 আউটটা দিই দিন 5টা দিন কস্টোডি সার্টিফিকেট আনুন এটা কোনটা item number 5 है दिन कॉस्टेड सर्टिफिकेट है दो बारोज वो रिजेक्ट ही थी की सिंगल मर्डर
Okay.
Jack Road to Marla Lepage, basic school. PW7 is an eyewitness. But during trial, Acha, he did not support the prosecution case. Declared hostile. After circumstantial evidence in conviction is. Let's do it out. See item number 5. This is an interim application filed for bail. In court, let the interim application be registered. Land counsel for the petitioner submits that the petitioner is in judicial custody for more than 12 years. The area you custody certificate upon the land council for the state has produced the custody certificate which also substantiate the submission made by the land council for the appellant. Stop. It is further argued by the land council for the petitioner that the eyewitness to the occurrence, that is PW7, didn't support the prosecution case for which he was declared hostile, and the case is based on circumstantial evidence. And since there is no chance of early hearing, the bail application may be favorably considered. Considering the submission, nature of evidence available on record, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
I have filed for relation of
Fine day file করবেন এটা ফাইল করবেন স্টে রিলেশন অফ ফাইন সেটা বি রেজিস্টার্ড করে দেবেন
communication.
bail allowed, stay fine. Yes, next. And this order to be communicated. Yes, next. Wait, then custody certificate then. 12 বছর এটা লেডিটা रुक्षाना लिखा है जी
मला रुखसाना बेगम
हाँ
13 वर्ष
अच्छा लिखिए the petitioner the land counsel for the appellant has filed a bail application let the IA be registered and counsel submit that the petitioner is in judicial custody for more than 13 years including the period of remission. Land counsel upon it produced land counsel for the state has produced the custody certificate to substantiate the submission made by the land counsel for the petition. Land counsel for the petitioner further submit that the petitioner is a lady and there is no chance of hearing of the appeal in the near future. And taking into account the period of detention, the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail, considering submission, nature of evidence available on the third period of detention in judicial custody. And since the petitioner is a lady, we are inclined to release the petitioner on bail allowed.
order may be communicated.
Order commented. Yes.
Okay. Item 29.
Lordship. Lordship, I am appearing appellant number 2.
ये फाइल करूँ तो लेडीटा रही आपको कुआउची Prisoner's petition has been received regarding engage. You are Mr. Vishwaranjan Swai?
No, my lord.
How?
Suryakant Dwivedi.
अपन कहाँ पे फाइल करते
File करनो assist prisoner petition assist.
appellant number कहाँ पे 1 ना 2 2 पे
My lord.
यदि लिखा है कि prisoner's petition has been received from appellant number 2 Kasinath Luhari regarding engagement of advocate Vishwaranjan Swai in place of Deepak Ranjan Mishra. Wakalatnama filed. You are not Mr. Vishwaranjan Swai. तो सी लिखी दोषी हमको आउडा चाहिए वो इसके द्विवेदी चाहिए लेटेस्ट कूटा और इटा on 3 shot. अच्छा are you filing that वकालतनामा? लिखो though 2 prisoners petition has been received from appellant number 2 regarding engagement of the counsel for him to conduct this criminal appeal, but the prisoner's petition dated 29/8/2025 is the latest one, wherein request has been made for engagement of Mr. S.K. Dwivedi as his counsel. Mr. Dwivedi has filed the Wakalatnama, which is accepted. The land counsel appearing for the appellant number 2 seeks for an adjournment put up this matter after ensuing puja holidays. किंतु ये केबे टू कस्टडी रे सब अछंती है
25/8 to 2024.
2014 we are concerned about that lady Hemolata हाँ सी 2014 से ये appear करना थी nobody is appearing Mr. अच्छा आपको engage करे तो वहाँ से सूर्यकांत द्विवेदी को as amicus curiae for appellant number 1. अच्छा since no one is appearing for appellant number 1 Hemolata Luhari, Mr. Suryakant Dwivedi who has entered appearance for appellant number 2 is also engaged as the amicus curiae for appellant number 1. Other likely 6 for an adjournment to file an application for bail for appellant number 1. Lekhala file कर देगा. Yes, next.
Appellant number 1.
हाँ, custody certificate of the appellant number 1 be obtained in the meantime, है ना? Yes.
In item 30, I seek an adjournment because the appellant number 1 and 2 are on bail. Inadvertently, 3's bail application was last rejected and it has not been renewed. I may be given one adjournment to file the application for bail on behalf of appellant.
ये 3 टाउ जी lady
Thank you.
में अच्छा हो रहा है Mr. mention is made on behalf of, and how many years she is in custody?
She is in custody since the date of judgment, my lord, 6/2/2023.
No.
They were all on bail.
They were all on the
Again, during trial.
Hon'Ble and counsel appearing for the appellant. You are appearing for all the appellants.
My lords.
Appellant 6 for an adjournment, put of this matter after puja holidays, entering puja holidays.
Copy में भी
Bail लगे माने hearing ହେଇଛି copy ଆଗରୁ ଦେଇଥିଲା deposition.
So
ଆଜ୍ଞା ଦି ଜଣ bail ରେ ଯାଇଛନ୍ତି ଏଇ court.
So you get the deposition copies in the pen drive. You take the land counsel for the informants, also the land counsel for the state are permitted to take the deposition copies of the witness in their respective pen drive. Pen drive ne nahi jana. Soft copy is here. Yes, next.
Grateful.
Item 31.
Yes, Mr. Muria.
I'm BC Melon.
Yeah.
I for bail Melon. Offense 302.
The petitioner is a lady as it appears.
Lady. Constitution 29/6/2022, man. There is no eyewitness to the occurrence, man.
Just a minute. 29/6/2022 अच्छा है का केस. जजमेंट देखिए. 302 केस.
There's 8, man.
Custody is
BB on 30/6/2022 शुरू डेट ऑफ जजमेंट पर्यंत सियोर तापर
बेसी नहीं
माने 3 वर्ष ऊपर हो गया
डेट ऑफ जजमेंट 25 पार्ट
हां नहीं कंटिन्यू कर दी तापर so she has not been released on bail either during trial or so yes what is the evidence?
There's no eyewitness to the occurrence, my lord.
Then how he has been found guilty?
27 Indian Evidence Act. Statement recorded.
27 Evidence Act.
Yes, ma'am.
What was found at your instance?
Amtu Gamucha.
Gamucha.
Amtu Gamucha towel.
Mother killed her daughter. Mother killed her daughter.
No, it's all right. We want the what are the evidence?
That's kind of PW3, my lord. Only she stated, my lord, मुझसे गलती हो गई.
Acha, you come to paragraph number 17. The page number, internal page is 15. There the evidence has been discussed. I think you and the deceased both were in that house and extrajudicial confession was made. When they came, the villagers came.
For PW3, my lord.
He could notice the victim daughter of the so-and-so was lying dead. And mark of injuries were there on the neck.
Only part is there. मुझसे गलती हो गई.
मुझसे गलती हो गया. On so.
For the PW3, my lord.
19. Yeah.
On the following sequence, the receipt was lapsing by PW2.
Good in para 19.
19.
Now with regard to the evidence of investigating officer, that 19 para?
19. 1033.
30. You do not know 33 mana no. You trial court judgment kotha puja. Trial court judgment para 19.
19.
19 now with regard to the evidence of.
It's mine.
Now
we regard the evidence of investigating officer who has supported the disclosure statement of the accused baby, teacher of the towel, mark MO1 and MO2. With cross-examination, no other suitable explanation has been offered by the defense in a failure to dispute the expert opinion or dispute the investigating officer on the veracity of discovery of the fact of the conditional evidence act. As such, in the aforesaid backdrop, hopeful with a small amount of evidence, the prosecution could successfully establish its case in the following sequence. That is, The deceased was last seen by PW2 at about 12 o'clock playing outside the house. 2. At about 5 p.m., the accused body screaming sound heard by the neighbors. Had the mark of injury on the neck of deceased found by PW3 and the accused body admitted or guilty by saying मुझे गलती हो गया. Then disclosure statement of the accused body in pursuant towards earlier statement had by PW3 leading to disclosure towel. Next, mark of injury and weapon of offense used. The opinion of doctor leads to the fact that injury can be possible with weapon of offense used for strangulation.
So mainly two things that one is of course the last scene. Second is the extrajudicial confession मैंने मुझे से गलती हो गया. And third which is जो recovery of the towels. These are the evidence and remain in custody for 3 years. कौन करेगा? बहुत से कहते यार ये lady टारा बहुत से कहते हैं.
30 years.
She killed whom? Or she has killed her? Mother. Doctor को मारी थी ना ये doctor को मारी. What is the age of the daughter?
13 years. 13 years.
Oh, why he killed her daughter?
Afghanistan.
Why? What motive?
Motive not proven.
Motive matter is second time marriage.
ये होची से स्वामी रो प्रथम स्त्री रो झियो ना कौन? अच्छा ये अच्छा याकू मैरिज करची. Tutti for next after puja holiday next.
Item 32.
Yeah, please. Item 32, madam. I am filing for a bail. The case is under 302. 30% the petitioner one is the lady, another lady is the 57 years old, another is the 27 years old. madam.
Region जाकर lady. ना खाली petition number अच्छा appellant number 1 is a lady. कांचन बेरा application टा कोड़ा ना गोटे कर फाइल कर दी.
Custody since?
Since more than 8 years. 8 years, 7 years. Something report as per report till now is 8 years. 2019.
नहीं 2018 17/8/2018
Yes, ma'am.
फाइनल फॉर्म देखो जैसे बेल ले जाई न थी वो ट्रायल कोर्ट रे ताले 7 इयर्स एबो हो गया.
No, ma'am. Bail लेना.
नहीं जस्ट बहुत हुआ ना यदि बेल ले जाई न थी ताले 7 वर्ष ऊपर ही गया. Order sheet shows accused persons produced in custody. UTP.
This is IO is the informant. Two cases has been registered in PS case. One is the UD case, 2 of 2018. Another is the 128 of 122 2018.
देखिଛନ୍ତି कौन अच्छी मटेरियल.
Yes, ma'am.
कौन
The 1 to 5 is the hostile. Another the husband of deceased also stated before the MO. He is taking poison. She is taking poison. He is taking poison.
ये सोची 302 रो.
Yes, ma'am.
हला 302 रो एविडेंस अपन कौन अच्छी कोन जोड़ा नाही अपन कोन. What are the evidence which are available on record on the basis of which the London trial court found you guilty?
Yes, ma'am.
Hostile ହେଇଯାଇଛନ୍ତି ସେଗୁଡାକ ଛାଡି ଦିଅନ୍ତୁ.
As per the medical legal case, as per the report of the doctor.
That's all right. It's a case of homicidal death. But what is your involvement? How it has been established for which
Schedule 14 is the eyewitness.
କହୁଛନ୍ତି ଦେଖି PW 14 କଣ eyewitness?
No, my lord, I don't think.
My lord,
I am the informant in the case. I know the accused. Sanction and so on so.
this is my wife. Incident took place 5 years ago. One day about 9 p.m. in front of my house on the alleged dated such and such. I told my wife to serve dinner. My wife told wait some time and she went to the house of the Counsel to bring the utensil. My wife.
Kanchan Behra is the appellant, number one.
Yes, ma'am.
My wife, after seeing the situation, my wife returned from there and seeing my wife, both the accused person chased her. While my wife was in the front of my house at the time, accused Surendra detained me and accused Kanchan assaulted to my wife by means of a steel
Chottu.
to her backside head. The accused Kanchan assaulted 3 to 4 chottu blows to the backside head and to her back. Due to such assault, my wife has sustained bleeding injury. I could not bring my wife to medical on the next day morning. I took my wife.
So who is the doctor?
PW8.
ଗୋଟିଏ injury ଅଛି.
PW8 and 9. PM report PW8 and 9.
ହଁ ନାଇଁ ଗୋଟିଏ injury ଅଛି ଦେଖନ୍ତୁ.
Yes, ma'am.
Head ର.
14 says repeated assault.
Three abrasions ଯୋଉଟା ଅଛି ସେଟା ହଉଛି left shoulder ରେ.
Shoulder ରେ.
ହଁ ବାକି ଯୋଉ 6 number ଟା ହଉଛି stitched injury on the occipital region. So that is the case.
Sir, my lord, the PW
Cause of death is due to the damage of occipital region, brain as well as head injury.
But PW 14 says 3 to 4 blows.
Yes, ma'am.
And that one head ସେ କହୁଛି ବୋଧେ ଚଟୁରେ ଯୋଉ ମାରଲା
Kanchan Behra assaulted 3 to 4
blows on the backside of the head.
ଦିଟା ତା କାନ୍ଧରେ ବାଛି ଆଉ ଗୋଟେ ମୁଣ୍ଡରେ ବାଛି ଯୋଉଟା
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner, the कितने number आई है? 3325. This application has been filed by both the appellants. However, the learned counsel for the petitioner confines his prayer in this application for appellant number 1, Kanchan Behra, who is a lady and is in judicial. अच्छा से assault तानार किस कौन अछि?
सुरेंद्र FIR नहीं.
FIR नहीं, allegation भी नहीं.
Eyewitness के दे?
Item 14. Schedule 14.
किसी नहीं लगता.
What is there? Against him, nothing.
Both the appellants.
Detained me and
the learned counsel for the petitioner submit that the petitioners are in judicial custody. Final form देखो. For lady टा होची 16/8/2018 तारो आरोटा
25
एक period for more than 7 years. And PW 14 is an eyewitness to the occurrence, and he has stated that the appellant number 2 detained her, the deceased. PW 14, the husband of the deceased, is the eyewitness to the occurrence, and she has stated that the deceased was detained by appellant number 2, and appellant number 1 assaulted the deceased by means of steel chottu on her backside of the head, and gave 4 chottu blows to the backside of the head as well as to the back. Land Council further and the evidence further indicates that the deceased was shifted to the hospital and 2 days after she succumbed to the injury. Land Council placed the evidence of Dr. Kede PW8, which indicates that there is only one injury on the occipital region, and the cause of death was also due to damage to the occipital region. Land Council submits that in view of the nature of evidence available on record, and since there is no chance of early hearing of the appeal in the near future, the petitioner number 1 is a lady, and against petitioner number 2, there is no specific overt act of assault. Both the petitioners may be directed to be released on bail. Land Council for the state placed the evidence of PW14 as well as PW. Considering the submission, nature of evidence available on record, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail. अच्छा स्टे रियलाइजेशन ऑफ फाइन स्टेट वाला कर दो एटा कितना नंबर आइटम आपन 32 तो यस हां बेल अलाउड स्टे रियलाइजेशन ऑफ फाइन यस ओनली आइटम 3 is left beyond. Even the custody certificate as well. Ida, କେତେ ବର୍ଷ ହେଇଛି 13 ବର୍ଷ ଅଛି ଲେଖନ୍ତୁ this is item number 3 JCRLA number 48 of 2014. The Learning Council for the appellant files an interim application for bail, so also for stay of realization of fine. Both the interim application be registered. Land Council for the appellant submit that the appellant is in judicial bail application is in custody for more than 13 years, and there is no chance of early hearing, and therefore the bail application may be favorably considered. And Council for the state has produced the custody certificate, which also substantiate the submission made by the Land Council for the appellant regarding the custody period. The custody certificate is taken on record. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail, stay realization of. Order to communicate over this year, huh? I would take matter for you, na? And cherry number that you go each other. That's in no, order for the file
extension of time is there, item.
Yeah.
Extension of time is 42.
33.
42 again. It is kind enough to grant me interim bail, and day after tomorrow it is going to expire. And
42
again, I have filed an application for extension of interim bail on the ground that the doctor has recommended for my own operations, and I have also given the copy during my jail period. When I was in custody, I have also undergone that particular operation by the jail authorities, and now can grant me interim bail for a period of 3 months.
Well, have you taken instruction on this interim application? ଯାଇଥିଲା ଆମେ ତାକୁ ଅର୍ଡର କରିଥିଲୁ ତାକୁ ବାଇ ଅର୍ଡର ଡେଟେଡ କେବେ ଯାଇଥିଲା?
He has been granted by order
20/6/2026
And is case submitted the bill
ତା ପୂର୍ବରୁ ମଧ୍ୟ ବେଲ୍
again, ସବୁ time there is absolutely no adverse. 26 he has been released on bail, interim bail. It expires on
ତାର ହେଲ୍ଥ ଗ୍ରାଉଣ୍ଡରେ ଏକ୍ସଟେନସନ ମାଗୁଛନ୍ତି ଏଟାକୁ ଛୁଟି କରୁ ରଖି ଦଉଛୁ ହେଲା ଦେଖନ୍ତୁ IA number so and so there is an application for extension of the interim bail period. It is stated by the land counsel for the petitioner in the interim application that paragraph 4 ta dekhi ke likh de the relevant medical certificate has been annexed to the interim application. Annexure A kahin ऐसे तो नहीं स्कैनिंग है फाइल कर ओपीडी प्राइवेसी ऐसा ऐसे कहीं नहीं ओपीडी कार्ड का तो लेता मैं सीधा सत्य वाला ओपीडी भी गोटा जो लिखना दी IA रे 2584 इलेक्शन annexure 1
There is no annexure.
नहीं देखो आज ना रेकॉर्ड अच्छी नहीं
the date of filing the IA.
just a minute that is not attached to this interim application though it has been mentioned in paragraph number 3 that the copy of the medical certificate is annexed here with that annexure 1 A but that is not there so that is এটা আগর নয়
21 the medical certificate is dated 21st August 2025
2584 application. I know. No, you have not filed.
what is that अपन बार अच्छी बर्तन
अच्छी
देख लो माने it would justify that after being released on bail you are
yes man
ସେଇଟା କହୁଛି ଦରକାର
but let me see the top 3-4 lines from the top left side
ଆମେ ଏଠି ଅଛି ଯେ 21 ଅଗଷ୍ଟ 2025 ଆପଣଙ୍କୁ କପି ଦେଇଛନ୍ତି ଏ ଯୋଉ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଅର୍ଡର ହେଇଥିଲା ତାଙ୍କୁ 20/6/2025 ରେ ବୁଝିଲେ ତାପରେ ର ଏଇଟା ହଉଛି SCB ମେଡିକାଲ କଲେଜ ର Prabhasis Mishra housandi patient is the petitioner and he was treated and some medicines were prescribed and the lekhuchanti kon problem tankar each interim application here would a copy rakhi diyo
I'll give
and give a copy also to the state council
yes man
these are all documents which relates to this is 21st a document at the end because after being released on bail the release orders these are the documents
the
documents for that fourth listing
नहीं एबे लेटेस्ट डॉक्यूमेंट से लिखी चंदी मध्य दागर आभरमेंट नहीं चंदी इंटरिम एप्लीकेशन ने बट इनएडवर्टेंटली ही हैज नॉट फाइल्ड इट
copy may be also.
हां कॉपी दी एक गोटे केवल नहीं ओडिए छ सेटा कोन
अच्छी
एटा हम ये फाइल कोर्ट फाइल
आगे कोर्ट
फाइल मना को
these are it is my mistake these IA फाइल को गोटे application for bail लिखि देथिल गोटे तापर जे ताको करेक्शन आउट सेपरेट फाइल कली application for extension ठीक है
the relevant medical document dated 21st August 2025 is also annexed to the interim application copy ta thang the state council copy of this one so is furnished to the land council for the state of this matter on such and such it extension is given till next week item number 42 extension बाकी जोड़ा तो नहीं ऐसे चलिए
Item 51 out of interim order. Doctor, this mother health was serious.
Item number
41. Last date your lordship directed for instruction
41 pra gala eta nahi ye jo manas chand par kitna number
42
अच्छा extension
Sir, item load 45 can be taken up tomorrow. That's the matter where
this will go after এটা মিস্টার লিখ দেবে
45 টা স্যার
সিনিয়র অ্যাডভোকেট ইজ প্রেজেন্ট সব আফটার ଏ ଖାଲି ବେଲ୍ ମ୍ୟାଟର ଗୁଡା କାଲି ଆସିବ ଯେତିକି ରହିଗଲା
Civil matter କିଛି ଦେଖିବ
ମ୍ୟାଟର ଡୋଣ୍ଟ ୱେଷ୍ଟ ଏନି
civil matter